Welcome everyone to our Understanding Agricultural Law educational series webinar. This series is geared towards attorneys and other agricultural advisors to provide basic information on agricultural law issues. As we move forward, we will be drilling a little bit deeper on some specific agricultural law topics as well. And this Understanding Agricultural Law webinar series is a product that the Ag Law Center is working with the Agricultural Business Development Center at the Pennsylvania Department of Agriculture, and the Ag Business Development Center. Their focus is on, as you can see on the screen, is really supporting a variety of business areas to help farmers. And this particular project, we are working with the advisors that are assisting Pennsylvania's agricultural businesses. This is the third webinar in our series. You can see the first two webinars have been conducted over the past 2 months. The first one focused on the basics of agricultural labor. Last month, we talked about leasing farmland for energy development. And then today we're going to talk about the basics of land use regulation. Now, if you weren't able to attend one of our prior webinars, we have those videos of those webinars are posted on our website. Now, I'll be giving you some more information on our website here in just a few minutes, but we'd encourage you to take a look at those prior webinars. Our next program in July is focusing on statutory protections for agricultural operations. And specifically, we'll be talking about Pennsylvania right to farm, the ag area security law, the clean and green, and acres municipal ordinance review. In some respects, next month's program is kind of a follow-up to what we're going to talk about today, because a lot of the topics for today kind of lead into those topics. Now, we will be planning the schedule for the following for next year very shortly, but we would encourage you, if you have any suggestions for general topics or for specific topics, please let us know, because we definitely want to be responsive to your feedback. Now, I mentioned I wanted to highlight our website, just to let you know some of the resources that are available on it. The address is aglaw.psu.edu. And you can see we have a variety of resources. You can see, just moving across the menu on the top, we have all of our events to register or to get resources after the event has concluded. You can go to our events site. We have publications, research by topic, watch or listen. So all of our YouTube or other video products are listed there. The Agricultural Law Weekly Review is a product that we prepare each week. If you want to keep up to date on all the various legal developments, please check our website or sign up to receive that directly. We also have, under the research by topic section, we have a number of virtual resource rooms. This is an example of one, the Pennsylvania's Right to Farm, where you can find cases, statutes, regulations, other publications on that specific topic. Agricultural law issue trackers take a particular topic and really, in kind of a timeline format, give you all of the relevant developments for that particular topic. Now, each of these topics are somewhat different, organized somewhat differently based on the topics, but that's the general idea, is that we're trying to give you a timeline of developments. We do have podcasts, so if you prefer to get information through podcast, a lot of the content from our weekly reviews is available on podcasts, and then we also have some podcasts that focus more specifically on individual topics. We also administer Pennsylvania's Ag Mediation Program. So if you have clients that you think may benefit from this, please let us know. Jackie Schweikler is the program coordinator, so Jackie can address any questions that you have. Okay, now some ground rules for today. The webinar is being recorded. We would ask that you use the Q&A feature for any questions. We will, for those of you that are looking for Pennsylvania CLE, this program is authorized for 1 substantive credit. The link for the CLE form will be posted in the chat. As a way for us to verify attendance, we will be giving you a code word at some point during the hour. So you have to put that code word in. I think the form has something labeled like attendance verification or something similar to that you can put the code word in. Okay, so today's program, we're going to talk about the basics of land use regulation. Brooke Doerr, staff attorney at the center, will start and we'll talk about the municipality's planning code and agricultural uses, and then he'll move on to some ag relevant provisions in general laws, specifically focusing on the Uniform Construction Code, erosion and sediment controls, stormwater management, land development. And then I will return and I'll talk about nutrient management and odor management. So with that, Brooke, I'll turn the floor over to you. You can take the screen from me.
Okay. So situated here. There we go.
And then you just need to put it into presentation mode, and it looks like you're good to go.
Okay, there we go.
There you go. It looks
okay.
Good.
All right, good. Don't forget our website address because it's so easy, aglaw.psu.edu. And let me, oh, wait a minute. I realized I am all the way at the end. Let me go way back, sorry. Just avert your eyes if this is gonna, there we go. Okay. All right, understanding the basics of land use regulation of agriculture. And we had originally advertised this and sort of conceived of it with the word local land use regulation of agriculture in there. However, sticking with the theme of what we've been doing in the kickoff of this, what is it turning out to be, a monthly series, we are doing a very high level view of a bunch of topics, and then we'll start to drill down. So we didn't really want to take on a concentrated hour on basically zoning hearings and practice in front of supervisors and that very, very specific thing that might fall under the word local land use regulation. So this is more of a potpourri, so to speak, of state and local, depending on who is the proper enforcement agency or entity and where the requirement comes from or where the issue comes from. So it's more state and local regulations that impact ag uses, not so much concentrating specifically on all of the very, very local municipal issues, although we're going to start with a few of those. So hang on for a minute. And again, Ross told you about the series here. This is a nice statement of our series. We'd like to get more lawyers involved, or excuse me, more non-lawyers involved. So please spread the word if you're so inclined to others, crop insurance agents, business consultants, engineers, all kinds of people, accountants who have ag clientele. We'd like to really make this a broad spectrum to serve the interests of PDA's Ag Business Development Center. Okay, these are links for the past webinars. Okay, here's our topic for today. Oh, excuse me, that's our topic for the next time, July 22, and that will be somewhat picking up on what we're doing today. And this kind of gives you a breakdown and shows you, as Ross did, as to the topics that we'll be covering next time on the bottom of the screen here, and the topics we'll be covering today. And they all do kind of hang together because again, it's all about ag uses and the various things that come into play from, as any of you do this, you know, it's from multiple angles. Sometimes, you know, it's, you know, there's so many different balls to juggle, and sometimes the impact of a particular requirement is small, or it's a small requirement, but it can have a big impact, or it's a big statute that only has one thing that keeps, you know, coming in when you're dealing with ag clientele. And some of the things that I tried to concentrate on were a lot to do with when I was a young lawyer and not really knowing what I was doing. Some might say I'm still there. And the kind of things that I would have loved for someone to have taught me at that time. First, before we go into some of the actual sort of statutory and other requirements that come into play with ag uses, let's go over something that's always good to have in your back pocket, which is Pennsylvania has an executive order that's still in place. It's been revised 4 times, and it is an executive order that essentially says that the Commonwealth of Pennsylvania state government will engage in a systematic process of promoting the viability of agriculture. This is a great thing to pull out of your back pocket if you're ever in front of a zoning hearing board or a board of supervisors, and it looks like your farm clientele is really, you know, taking it over the head, and, you know, bad situation where they're, you know, unable to operate under the regulatory structure that they're being presented with. It's always nice to pull this one out every once in a while. Again, it goes all the way back to 82 and last revised in 2003. And this is the actual executive order itself. And I put little stars over in the margin that indicate some of the important areas. It's worth a read, and it's worth a cite, you know, every once in a while when you want to make a point to indicate that an ag client is not getting perhaps the kind of treatment that you would want them to get in front of some type of local agency. It shall be the policy of the Commonwealth to protect, through the administration of all agency programs and regulations, the Commonwealth's prime agricultural land from irreversible conversion to uses that result in its loss as an environmental and essential food and fiber resource. And again, this has been multiple times reissued by successive governors, last time by Governor Rendell. It goes through a hierarchy structure of prime farmland and talks about the following order of priority in terms of how the state government, this is obviously does not have reach to local governments, since it is only issued by or to those under the governor's jurisdiction. Preserved farmland is the highest priority. Next is farmland in ag security areas. And we're going to talk about ag security areas next time, what kind of, how you form them, what kind of benefits they bring. Preserved farmland, obviously, many of you who are here, of course, know all about, you know, what we're referring to. That's land that is subject to an ag conservation easement, but I do need to tailor our, you know, topic to beginners, because that is the series that we're doing here. And by the way, I do apologize for our out-of-state people, or to our out-of-state people, because this is going to be really a Pennsylvania-centric webinar. We do get a lot of out-of-state signups. Okay, next priority after preserved farms and agricultural security areas is farmland that's enrolled in clean and green, and then farmland that is in an ag zone. And then it starts to go into essentially the land capability classes as established by, you know, USDA's NRCS through the soil survey. And so that kind of gives you, it ranks the type of farmland in terms of what's the highest priority, what's the next priority, et cetera, et cetera. One thing that you should note in here that does not exist is over here, and I think this is maybe page 4 of the executive order, talks about all agencies under the governor's jurisdiction shall amend their individual documents titled Guidance for Implementation of the Agricultural Land Preservation Policy. Now, I can tell you that from my years at the Department of Agriculture, all 12 of them, never ran across a document called that. So I'll just leave it at that. I highly doubt that there is the residue of any such document at any other executive agency, and perhaps it's time to dust those things off. in any event, now when you start talking about the land capability classes and the soil survey from NRCS, when you're a young lawyer and our target, or just someone who wants to learn about things that are not within your existing knowledge base right now, you say, well, how do I find out the quality of my soil and where this or my client's soil and where does this fall? Well, here is the link. And by the way, I have links all over my PowerPoint. So if you don't, I'll gladly send you one directly if you email me, but it will be on our website so you can download it. Here's the NRCS Web Soil Survey website. It's wonderful. I was just on it this morning. And I have this map over top of the home page, but you hit this green button and you go into this map process, and it's a wonderfully interactive map. The amount of data manipulation that you can do here is just amazing. And you can put in a street address and you will find whatever you're looking for. And you can look at the soil surveys and you can find out the types of soil that a particular parcel has, and just a wealth of information. So it's a great thing to know of and know where to get it. Now, another little tip about things that can help you when you're representing ag clients and you're not as familiar as you want to be with particular laws. DCED, Department of Community and Economic Development in Pennsylvania, Local Governments Services Office publishes an amazing collection of, and there's 50 publications that they publish. They're all downloadable at this link up here. And there's just an amazing wealth of information here. So I have found these to be great when I'm brushing up against an area that I'm not that familiar with. And they really do. And also they tell you how the municipal employees that you may be dealing with might be trained, because a lot of these things, of course, they're made for training and educating municipal employees. And so there's just all kinds of topics here. And of course, there's a whole set of them on land use issues here. And so very helpful website to know about. And again, here it is. You can go to that link and download all of that stuff. In fact, I'm going to show you one of them, which is called Planning for Agriculture, which Ross Pfeiffer did have a role in the last revision of this, which was in 2014. I've looked it over just recently. It's an excellent resource in many ways. Got some very statutorily based examinations and some good narrative that helps you understand the reasoning behind certain things. And so no sense in reinventing the wheel here. So you'll see from the table of contents that much of what is in this document is in fact the things that we're going to talk about between today and particularly the next session in July. So I didn't even know of this publication when we planned out these two webinars, but it just so happens that the same collection of statutes and provisions regarding ag uses were collected here. So it's an excellent resource. It's almost like the yellow book that we used to all get when you went to a webinar or went to a seminar, I should say, a CLE. It's almost like the yellow book for today's session. Now, let's talk about the MPC first. We all know of it as the Municipalities Planning Code. And of course, we know that it is the enabling legislation for any municipal regulation of land uses in Pennsylvania, be it agricultural land uses or others. And it is the basically the sole authority that a municipality has to regulate land uses. The purpose of the act is instructive to read, and it's always good to go back to some of these things again. Nice to cite them sometimes when they support your position for your client. To promote the preservation of the Commonwealth's natural resources and prime agricultural land. This is language right in the purpose of the MPC, to encourage the preservation of prime agricultural land, to ensure that municipalities enact zoning ordinances that facilitate the present and future economic viability of existing agricultural operations in this Commonwealth, and do not prevent or impede the owner or owners' need to change or expand their operations in the future in order to remain viable. Great stuff. Good stuff to put in briefs when you're in front of a municipal board of some kind, when you're trying to get approval for an ag client. Just a wonderful way of stating that it is the policy of this of the Commonwealth, and in fact, by citing the executive order, and in fact that it is the purpose of the MPC to serve this this articulated purpose. Obviously, the tools in the MPC, most of us know them, the three biggies: the comprehensive plan, the zoning ordinance, and subdivision and land development ordinance. I'm going to talk mostly about the zoning ordinance and a tiny bit about subdivision and land development ordinance here today. Okay, here is a quote from that Planning for Agriculture document, which is more in the category of narrative, but it's basically lays it out fairly succinctly. The purpose of ag zoning is to protect, in other words, the designation of an ag district, and most of us are familiar enough to know that the MPC has some options and provisions that directly deal with how to set up ag zones and features that you can have in an ordinance. It's somewhat, I'll put it this way, there's many of those documents on the DEC website, just like this Planning for Agriculture, that are geared towards those who are doing municipal ordinance drafting. Purpose of ag zoning is to protect farmland from incompatible uses that would adversely affect the long-term economic viability of the area within the region. Zoning accomplishes this purpose in three ways: protecting prime agricultural soil, maintaining large areas of agricultural land, and minimizing land use conflicts. Pretty succinct statement. I like that. Obviously, we may not be accomplishing that on all cylinders right now. There's always dust ups and issues, particularly the land use conflicts, but nicely stated. Okay, now let's look at the basic authorization or enabling portion of the MPC for what it says about agriculture. Okay, zoning ordinances may permit, prohibit, regulate, restrict, and determine uses of land. There it is. There is the prime directive of the MPC. Also, they can prohibit, regulate, restrict, and determine size, height, bulk, location, et cetera, et cetera. So, those are all the sort of the dimensional and the other types of requirements. Areas and dimensions of land and bodies of water to be occupied by uses and structures. Okay. Density of population and intensity of use. So in the articulation of a municipality's authority in their zoning ordinance under the MPC, intensity of use is the phrase that is used. Now, in agriculture, we all know that that is somewhat of a loaded term in this day and age, and that has come to have certain meanings. I just find it interesting that not sure that you probably wouldn't get two people who are in this field to ever agree on exactly what that means. So perhaps not the best words in a statute, but it's interesting that that was chosen back at the time. Protection and preservation of prime agricultural land and activities is actually one of the articulated powers of a municipality in enacting a zoning ordinance. Now, these are all the sort of the laundry list, but then it says, except, and this is their, it's not preemption language strictly, except to the extent that regulation of activities related to commercial agricultural production would exceed the requirements imposed under, and then it's got the little laundry list of statutes, and then it has a catch-all. So up to that point, up to the catch-all, it's not a preemption, language. It is would exceed the requirements imposed under. And most of us probably have run into this in our careers, that when you use those words, would exceed the requirements of some certain statute, there's sort of two ways to look at it, depending on which side of the fence you're on. Exceeding to the one half of a dispute is not generally perceived as the same thing to the other half of the dispute. But that's the wording that we have. And then there's the catch-all that says, or regulation or that regulation of other activity are preempted by some federal or state law. So in other words, there's the preemption language, which just basically says, well, if it's preempted in another law, then it's preempted. So, but it's interesting to know, or to note that falls in the exact introductory paragraph that 603 is the fundamental statement of what municipal supervisors authority is with regard to land use regulation. And this is noted right in that very paragraph, in the first paragraph of an articulation of a municipality's authority. So I think we'll always have a little bit of residual interpretive friction over what would exceed the requirements means. We know that there was a item of litigation that ultimately decided this Nutrient Management Act issue in terms of preemption. And in fact, that's ultimately how the case went, because there is express preemption language that was interpreted in a certain way by the PA Supreme Court for the Nutrient Management Act. But in any event, that's good to know that exists. All right. The MPC definition of what is an agricultural operation is notable simply because it is not, in fact, the exact definition that we've all come to learn to know now from the right to farm law, and which of course then has been picked up by the acre statute here in Pennsylvania. And so, but that normal ag operation definition has existed alongside this older, more traditional definition of ag operation. And there really hasn't been a whole lot of conflict, because the meat of them, besides the 10 acre or 10,000 anticipated yearly income thresholds, they're generally the same with regard to the language that appears in these definitions. But it's notable to understand that the MPC's definition of agricultural operation, like other definitions that come up in the ag statutes in Pennsylvania, does not include what I have in the red note. It does not include retailing or marketing of commodities at the or from the farm. And this is a recurring omission in most definitions of what is agriculture or what is an agricultural operation. Now, it's interesting, and we'll talk about this in our next session, that in one definition in Pennsylvania, the Ag Area Security Law, it actually includes retailing within the definition of agricultural production. And I think that's the term that they're defining there. So we've been on this several decades long journey of, will there be a uniform definition? We're getting closer and closer, but it's just good to know here's the MPC's definition. Now, let's talk about, so that's sort of the MPC in big terms, in terms of, how does it incorporate agriculture into its broad sweeping scope, so to speak. And that's as far as we're going to go, because this session, this could be hours long if we went further. So that's the purpose of this, is to give you these big overviews. Okay, now let's talk about some very specific issues that come up, and these are kind of the friction points, and particularly the friction points that are existing today that I've seen most commonly, let's just say, in the last let's say 15 years, with regard to the regulation, of land use, mostly from the local level, but some from the state level. And in this case, of course, Uniform Construction Code, while generally enforced by the locals, unless they took a pass on it, as a few municipalities did in Pennsylvania. But the recurring issue that we've all seen probably, or at least, if you're a young lawyer, you're going to see it someday if you practice in a rural area, which is the ag building exemption under the UCC. And I remember in 2004 when I was in private practice, and all the ag clients wanted to hurry up and get their building permits issued for projects so that they could be essentially grandfathered in before the UCC came into effect. So the problem that exists with the ag building exception or exemption to the UCC, and it's, again, the first sentence, very normal. Structure utilized to store farm implements, hay, grain, feed, other ag and horticultural products, or house poultry, livestock, other farm animals, or dairy products. Structure to grow mushrooms. Interestingly, a structure to grow agricultural and horticultural products was only recently added. That greenhouse operation for growing was not actually within this definition for a while. And then there's an exception for plain sect, housing of their horses. And then term includes a structure that is less than 1,000 square feet in size, utilized to process maple sap. So there you go. The maple syrup lobbyists got their 2 cents in. However, this bold sentence is where all the sticking point comes in. The term shall not include habitable space or spaces in which agricultural products are processed, treated, or packaged, and shall not be construed to mean a place of occupancy by the general public. And there you have it. That has become the sort of the I can't tell you how many clients I've had or distressed, ag operations or farmers who this is the phone call that you have with them. Explaining to them that if you're inviting the public into the building to occupy it in any way, shape, or form, that is not an agricultural building. And I remember when the UCC, used to be, or when the UCC was first enacted, the stable people who were, doing riding stables and housing people's horses, they were having big trouble with this. Now we're seeing this rash of problems with retail sales and other sort of value added expansions of traditional commodity production to include all this other stuff that is income generating in order to make ends meet. And this is the sentence that is going to be living with us year after year after year, until perhaps someone looks into, is there a way to resolve things such that all of this wonderful historic building stock that we have out there, and the outbuildings and the beautiful barns that are out there, can be utilized in some way without having to do retrofit with the handicap bathrooms or the sprinkler systems and all the other things that come with the UCC. So this is the bane of the wedding barn people's existence. This is this is the sentence that you really have to be aware of and understand, because most clients come in, they don't know why, they don't exactly know why they're what it is that's tripping them up. Until you explain this to them, and then they realize, like, oh, now I know that they weren't just making something up when they told me that I had to have sprinklers in the barn if I wanted to do a flower arranging class in there because I grow flowers out on the farm or something like that. I just had that recently. So that is the central issue with the UCC in terms of friction and land use regulation. We also have the three-sided market exemption, which seems to be sort of, I'm not sure who's actually able to use this, but this was an attempt to try to overcome this last sentence by saying, okay, we'll allow farm markets to be essentially, or we'll allow the public to essentially walk under the roof of a farm market on-site farm market, if you only have one per parcel, that they only engage in seasonal sales, that they're open on at least 25% of the perimeter. So that's why I call it the three-sided farm market. And that we're all familiar with this, which is that the structure is, or that the operation is selling at least 50% of their own products. Here's a little exception of if it's not on the actual producer's property, then it can only be standing for 180 days out of the year. It actually literally has to be broken down and removed, and not more than 1,000 square feet. So this three-sided market exception, I guess the question is at this point in time, has it done anyone any good? Has it overcome and allowed anyone to do business who was otherwise not able to invite the public onto their land for additional income opportunities because of this last sentence in the ag building exemption? I kind of doubt it, but perhaps. Most of the time when you explain to a client that this exists, they laugh. Okay, so now we talked about the UCC, and that's the hot issue there. Let's talk about E&S plans, erosion and sedimentation control plans. This is a basic thing that I would have loved if someone had explained to me when I was a young lawyer, and even not that many years ago when I didn't really understand it all that well. So the place to go to get your resources, DEP's page called Agricultural Erosion and Sedimentation Control is the source. They have a great thing called the Soil Erosion and Sediment Control Manual for Agricultural Operations. And it's the Chapter 102 regulations is the source of all the E&S control provisions. Okay, the basic rules. Best management practices, which are derived from NRCS's Field Office Technical Guide, are required if you have anything that meets the definition of plowing or tilling or heavy or animal heavy use areas. If you have either of those that disturbs more than or covers more than 5,000 square feet, then you need an actual ag E&S plan. And that is a permanent plan, not a temporary plan. That is a plan for your animal heavy use areas are going to be used, generally all year round. Of course, it will have provisions dealing with when you are plowing and tilling. So that's the basic rules with regard to an ag E&S plan. I'll keep moving in the interest of time, but that is obviously, an issue to understand if you're not familiar with it. Here are the definitions of what agricultural plowing and tilling actually means, and it does in fact include no-till cropping methods and heavy use or animal heavy use area. There's a definition right in 102. Okay, Stormwater Management Act. All the exemptions for ag for stormwater management plans went away years ago. It was a gradual process of just eroding the size of impervious surface or disturbed surface that you, impervious surface that you needed to have. And now it's simply become, there are no ag exemptions any longer. So obviously stormwater management's at the heart of our Chesapeake Bay efforts here. Too big an issue to cover in this webinar, but there is, and of course they vary from municipality to municipality. However, there is one issue that we can talk about that is hot right now, which is the high tunnel exemption from stormwater management plan requirements. That was passed in 2018, and it's had a storied success, and perhaps you could say, or a storied lack of success in practice for a number of reasons. What it said was that a high tunnel is exempted from stormwater management plan requirements if it does not result in impervious surface area that exceeds 25% of all the existing structures located on the owner's property. Now, note that it doesn't say plural, it says it's singular here. And a reading of this, is unclear at this point in time, and it's the subject of a great deal of consternation out there in the field. That does this mean each high tunnel can be up to 25% as large as your gross impervious surface? Or is it that all the high tunnels you want to build, 3 or 4, have to be added together, and that cumulative total of high tunnels can't be more than 25% of your already existing impervious surface? And frankly, that's a part of this statute that is unresolved right now. The sides have sort of queued up. The producers want it to be, it says singular. It may have been a mistake, but that's the way it goes. We know that there are statutory interpretation rules. We'll leave that for another time. The other problem with this provision is that the definition of high tunnel includes, and the general definition here is fairly understandable and what we would come to expect in the definition of a high tunnel, except it says it has a floor of soil. Okay, got that. Crushed stone, well, all right. Matting, pavers, or a floating concrete slab. So that kind of blows this whole thing up, because at that point in time, you're not talking about what most people would traditionally think of as a high tunnel. You're talking about something with a clearly impervious floor that is subject of much, capital investment and is, not mobile, capable of being removed. This is not what people would envision as a high tunnel. And that has caused all sorts of troubles, because now that townships are dealing with this, they're using this provision to basically say, okay, it's supported by a buffer or diversion system if it doesn't meet these sloping requirements, does not directly drain into a stream or other water course by managing stormwater runoff in a manner consistent with the requirements of this act. So what's happening is, in order to compensate a one-size-fits-all engineering look at your high tunnel, in order to compensate for the fact that high tunnels can theoretically have floating concrete slabs, what's being put out there as an acceptable way to manage what little stormwater might need to be managed in a traditional high tunnel that has an earthen floor, for example. The requirements that are being demanded here are way beyond what is necessary. They're engineering for a potential concrete slab floor. And this is the same definition that was used in some property tax exemptions for high tunnels as structures. And I can see, you can probably guess how that came to be. But that was obviously one of these legislative things there. Somebody got their say, got the concrete slab language in there, and that sort of blew this whole thing up. So instead of an exemption for something that looks like this, we now have municipalities having to deal with an exemption for something that looks like this. And so that has essentially resulted in townships insisting upon extremely burdensome stormwater controls, not a stormwater management plan, but extremely burdensome stormwater controls to meet this provision right here. And so right now, there is just a lot. I mean, I can't tell you how many times I've run into this issue with someone who's simply trying to put up a high tunnel of this nature, or 2 or 3 of them, and just gets hit with massively expensive requirements from the township with regard to stormwater controls, because it's a one-size-fits-all from the township's perspective. They're recommending what would work for what we have here on the right. Okay, now land development, subdivision and land development ordinances. Last thing here, and we'll turn it back to Ross. The two questions that you're always going to have in the ag world that are hot buttons with regard to land development plan requirements is what qualifies as a land development plan and what qualifies as a subdivision. The subdivision question is usually, of course, dealing with leases. And that's where you get some area where, and I wish someone had told me this when I was a young lawyer, that someone would construe a lease as a subdivision. So there is actually a provision in the MPC that does talk about this issue a bit. And, it basically says that if the subdivision by lease, in other words, if you're looking to lease a less than the entire existing farmland that you are in possession of to somebody for, crop farming, for example, if it's divided up into larger than 10 acres leasehold interest, then that is not considered to be a subdivision under the MPC. So that is at least a slight bit of relief from this idea that simply leasing ground can be considered a subdivision. Now, last issue, what qualifies as land development? This one really gets thorny because the definition of land development that would require a full-blown expensive land development plan, the engineering costs would kill many plans right at the outset, is any improvement for any purpose. Well, that's pretty broad. And then there is a provision in here with regard to leasehold. So even if you get over the the leasing is not a subdivision, you might actually get an argument someday that it's actually land development, because this is almost the same definition here. Then we have a provision in the MPC that attempts to provide a little bit of an answer, which is that a subdivision and land development ordinance may include, doesn't have to include, but it may include a provision that says that an addition of an accessory building, including farm buildings, on a lot or lots subordinate to an existing principal building, meaning let's say your main barn, for example, and then you're building some other accessory building, is not going to be considered a land development. Okay, well, that might get you a little bit of relief from a land development plan requirement in certain very limited instances. But other than that, you're always sort of rolling the dice with just about any kind of, as you can see, these definitions of land development don't require a building to be built. They can simply be an allocation of land or space. And the land development ordinance doesn't, that's about as far as it's going to go. And it's broad. It says an improvement for any purpose. So that is obviously, or that is a recurrent hot issue with regard to land development plans being required for, ag operations to, do relatively what is perceived, at least by the owners, as simple things. Okay. I'm going to turn it back to Ross. That's sort of the 40,000 foot view of, ag and land use issues that are hot right now. Let me stop sharing. Did I stop? Yes. All right, Ross, maybe I haven't stopped sharing.
No. Okay. So we have the code word. The code word is nutrient. Sorry, I have to get my video back here before I share my screen. Okay, so once again, the code word is nutrient. So for everyone looking for Pennsylvania CLE credits, this is the form that you'll put onto the attendance form. Okay, so I'm going to talk about nutrient management and odor management, and just to walk through a little bit of the legislative history. Nutrient Management Act was enacted in Pennsylvania in 1993 originally, and at that time, Pennsylvania really was one of the earliest states to adopt a nutrient management plan. And so, that established the requirement, that we're familiar with today in terms of the planning requirement. Now, in 2005, the statute that is commonly referred to as is ACRE, and that we're going to talk in July about the municipal ordinance review part of ACRE. And I think that's really what ACRE has come to be known for, that municipal ordinance review. But part of that statute also addressed nutrient management and added odor management requirements. Now, at that time, this municipal ordinance review statute, prior to 2005, when this act passed, I believe it was 2004, legislation was passed by the General Assembly establishing that municipal ordinance review. That legislation was vetoed by the governor. And then when the legislation or when that topic was reconsidered, and when the legislation was passed, this revision of nutrient management and the addition of odor management was paired with the municipal ordinance review in Act 38 of 2005. So sometimes you'll see Act 38 referring to odor management. Sometimes you'll see Act 38 referring to the municipal ordinance review. So same statute addressed those two topics. Okay, so just again, we're providing a big picture overview, and I want to make sure that you have the relevant legal authority. So when we talk about nutrient and odor management, the statutory authority is in Title III of Pennsylvania Consolidated Statutes in sections 501 to 522. The regulatory authority is in Title 25, and that kind of highlights the fact that this is really an issue that kind of crosses between the Department of Agriculture, the Department of Environmental Protection. So the regulations for nutrient management as well as odor management are in Title 25 in Chapter 83. My last slide here in a few minutes is going to touch on manure management, and that is also in Title 25 in Chapter 91. Now, the statutory authority for manure management comes from the Clean Streams Law rather than the Nutrient Management Act. Okay, now some resources that I would direct you to get more information on this topic. Penn State Extension has a lot of good resources on nutrient management. The State Department of Ag's website has a lot of resources on odor management. This third bullet point here is the administrative manual for nutrient management and manure management. This is prepared by the State Conservation Commission, and it really is focused on giving direction or giving guidance to conservation districts. But I think it's a good resource to look at, and you can Google that. You can find it on it's on that extension website that's listed under the first bullet. And then the fourth bullet, Brooke mentioned that earlier, the DCED planning for agriculture document. Okay, so nutrient management plans. Who has to prepare them? And the standard is someone who is, or an operation that is defined as a concentrated animal operation, a KO, has to prepare a nutrient management plan. And that KO standard depends upon the density of animals, as well as the relationship to the amount of land that the manure would be spread upon. So next slide, I'll go through an example, but we're looking at animal density and we're looking at the available land. And this animal equivalent unit is basically 1,000 pounds of animal weight. So, if the animal density exceeds kind of 2,000 pounds of animal weight per acre of land, then the farm is considered to be a KO. And this is an example that comes right out of the Pennsylvania Code. And so if you have 10,000 broilers, the standard weight would be 2.3 pounds. So you have 1,000 pounds of animal weight. Then you have to figure out what is on on a daily basis, on an average daily basis. Now, with a flock of birds, or you're going to have multiple flocks. So, the broilers are there for about 6 weeks, then they're taken away to the plant, maybe a couple weeks until you get another flock. And so in this particular example, I think they used 6 flocks per year, which would be 258 days. So you take that percentage of the number of days in the year, and you come up with the figure of on an average day, there were 16,257 pounds. Okay, you scale that down to on that 1,000 pound that we're using a kind of 1,000 pound standard. So you would have 16.25 animal equivalent units on this particular farm. Now, if this farm had 2 acres of homestead, 3 acres of wooded land, and 7 acres of cropland. 7 acres would be the amount, because that is the land that you could that would be available for spreading manure. So you do the math and you come up with 2.32. So this farm is just over the standard. So if it was a farm that had 6,000 broilers, they would not be required to complete the nutrient management plan. Also, even though density is kind of the main way to calculate who has to file this, also just if a farm is under 8 animal equivalent units, it doesn't matter what the density is. If they're under 8, they don't have to file a nutrient management plan. Now, any operator, any farm, they can file a plan on a voluntary basis. And, we'll touch on in July's program when we talk about the right to farm law, there are some advantages for a farm, even if it's not required, to still fill out a nutrient management plan. And that plan has to be prepared by a nutrient management specialist. The Department of Agriculture is kind of manages that process of certifying and providing for continuing education for the nutrient management specialists. And the nutrient management plan is submitted to and needs to be approved by the local conservation district. Now, there is a preemption provision in the Nutrient Management Act, and Brooke kind of touched on that, but it's preemption of local ordinances are preempted by the statutes, regulations, or guidelines if those ordinances conflict with the statutes, regulations, or guidelines. I'm going to talk about odor management next, and in that same statutory section, a different subsection, it provides for a preemption of odor management as well. Okay, so odor management the plans, they are required for new KOs or CAFOs, which is the federal definition under the Clean Water Act, and they're required for existing KOs or CAFOs if those operations are looking to construct or expand manure storage or animal housing. So if you have a farm that has been in I should say, if you have a housing, storage, or animal housing that pre-exists the enactment of this statute, and there are no changes made to that, there's no requirement for an odor management plan. But when you expand or construct a new facility, if you are a KO or a CAFO, or if you are becoming a KO or a CAFO, then you have to complete a nutrient management plan. Again, there are voluntary plans that are authorized. They have to be prepared by an odor management specialist, and they have to be approved by the State Conservation Commission. And what we're not going into a lot of detail, but these odor management plans, they're evaluating the site, the operation, to see if there are off-site impacts, and if so, then there are odor BMPs that need to be implemented in order to address those potential odors. And the goal isn't to eliminate, but rather to minimize these odors. Now, the last slide here, manure management plans. So any farm that applies manure has to prepare and implement a manure management plan, and or if they have an animal concentration area. So or pasture. So I mean, this is pretty widespread application for the manure management plan. Now, these plans, they don't have to be prepared by a certified specialist. The farmer can prepare them, keep them on site. There are a number of resources that kind of provide fill in the blank types of plans to help farmers with this. But I think it's something you need to be aware of, that there is this requirement, even though it's not, you're not going through an elaborate process or through a process as you are for those other plans. So with that, I guess we're at the top of the hour. We could just maybe see, we may have a couple questions.
That was amazing, Ross, that you got through that. I'm sorry to have cut into your time so much.
Fine. So let's try to take some questions.
Yeah, there's a question about, okay, does an ag building that comes into the definition of it was the exemption, the UCC exemption, apply to the entire building that comes in the definition of the language? Apply to if the public may only enter a very limited portion of it. And I have not seen, and it says, i.e., can a building be subdivided to keep part under the definition of ag building? And I suppose it's possible, but I have not seen anybody. If you're trying to expand your operation and invite the public in, those portions that the public are going to now be occupying are the portions that are going to take the big capital investment. So I'm not sure I'm following, what benefit there would be to leaving a portion of it, so to speak, or somehow cordoning off or subdividing a portion of an historic barn. And because, I mean, generally you're proposing to use the barn, and those are the portions you want to use are the portions that are going to require all that retrofitting. Maybe I'm not understanding the question well here. I haven't seen a lot of instances of that sort of thing, trying to essentially, divide the space. A barn where you only have to put sprinklers in a limited part. Right. Yeah. I guess that's theoretically possible. Haven't had any experience with that in practice and seeing that. I guess it is theoretically possible.
Okay, do we have any other questions? I don't see any. So once again, our next webinar in this series will be July 22nd, and we will cover some of the statutory protections for agriculture: right to farm, ag area security law, clean and green, and acre. So that we hope that you all tune in for that. And thanks again for attending.